Hey guys, my name is Anthony Bandiero, attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing another webinar on hot and fresh pursuit. We have a lot to cover. For those who are watching this, on demand, just understand that a few hundred of your fellow officers from around the country are also watching this live. So if I, looking over, that means I'm looking at the chat and I'm seeing if cops have any questions, any kind of commentary that I want to repeat. Also, these are kind of a little bit of fun. I actually enjoy these, the live versions of these, because it's actually like hanging out in a room full of cops, which is awesome. My brothers and sisters. Okay, so some quick disclaimers before we start. Number one, laws and agency SOPs may be more restrictive. If I'm going to teach the national standard here, but we understand, that some states are more restrictive. If you have any doubt about the legality of your actions, push up the chain. And finally, this course is legal education, not legal advice. I might be an orange attorney, but I'm not your orange attorney. Okay, I'm just saying it because I look a little orange today, but that's okay. I did get a little sun. I did get a little sun this weekend, but I thought I looked a little more tan in real life. All right, so we're going to talk about unprovoked flight, hot pursuit, fresh pursuit, protective sweeps, plain view seizures. We have a lot to cover in a very little amount of time. So I want you to get your money's worth. Unprovoked flight. I think that's like a really good place to start whenever you're talking about hot pursuit, right? Because that's like the quintessential hot pursuit. And as the Supreme Court has said, they said any refusal to cooperate without more does not furnish the justification needed for a detention or a seizure. But the unprovoked flight is simply not a mere refusal to cooperate. Flight, by its very nature, is not going about one's business. In fact, it's just the opposite. So, what I look for when I'm thinking about, unprovoked flight, what I think the courts are looking for are these three things. Number one is criminal activity, right? Running, I like to say mere exercise is not reasonable suspicion, right? Just running is not reasonable suspicion, right? But the running, it's the evasion. It's trying to get away from the police, right? So you want to describe the area, like what kind of maybe criminal activity could you tie this person into? You don't have to have anything very specific, but it should have some, kind of criminal activity. It could also be a nice neighborhood. Don't think about it's just the bad part of town, right? It can also be the nice part of town where there's an uptick in what auto burglaries, daytime burglaries, and so forth. Graffiti. The officer sees the officer. So the reason why they're running is because of you. See, when I see police, you either represent one of two things, either safety and security or a traffic citation. You do not represent jail to me, right? I don't think about jail when I see you because I don't commit crimes. Um, and then, but to some people that commit crimes, you represent jail to them, and they are trying to run away from you because you are triggering them. And then finally, headlong flight without provocation. Okay, now the criminal activity and so forth. Let's just quickly just watch this video.
Yo, give me a break, man. Hey, yo, slow up. Stop. Police officer, stop. Come on, man. Give me a break, all right?
Now, when I watched that, that first of all, one of the best movies of all time, Training Day, right? But when I watch that, I think to myself, when I think about unprovoked flight, I think about somebody running. But what about Snoop Dogg in the wheelchair? Does he qualify? Absolutely, right? We don't discriminate, right? If he's in a wheelchair and he's trying to get away from the cop and all those other factors are in play, they see that he sees the cop and he tries to wheel himself away, that can be unprovoked flight. Okay, so those are the three things. This case comes from Illinois versus Wardlow. Briefly, what happened in that case was the Chicago PD rolls into the West Side. Wardlow is like hanging out with some friends. He looks over, he sees, the cops, and he starts running, right? He starts running. And the cops chase. They end up finding like a gun or something in a paper bag that he was holding. And the Supreme Court upheld it because they said, look, the person's flight is an indicator of guilt, right? It's not just going about your business, it's the opposite, right? Here's also a case that makes us remember, though, that it's supposed to be unprovoked. What do we mean by unprovoked? We mean that the police officer is not really doing something, I don't know, aggressive to maybe create that flight. This is a case that kind of illustrates that, whether you agree with it or not. It's something to think about, in your unprovoked flight cases. A suspect's flight at the sight of officers who are targeting with a flashlight may provide a basis for fear of harm that has nothing to do with whether the suspect is engaged in criminal activity. Look, I'm not sure I buy into this, okay? But I'm just saying that it should be unprovoked, right? It should be unprovoked. You should not be doing something to taint the flight, right? Now, I don't give you enough facts about what really happened in this case. Why would the court think that somehow this is targeting him and making him want to run without, something else? But maybe this is a better example. Now, I don't show you the whole video because we don't just have time for it. But what I use that video for is, is that good unprovoked flight? Well, I think it's good as long as the officer was giving him a lawful order, right, to come over here. Um, but if let's just presume, just for argument's sake, that was not a lawful order, right? Hey, come over here. Let's say the officer did not have reasonable suspicion that young man was engaged in criminal activity. Would that be a good detention? The answer is no, not unprovoked flight. I think that many judges, not all, but many, most, could be convinced that giving somebody an unlawful order and then having them run as a result of that unlawful order taints the unprovoked flight part. However, as Mike is saying, under the Fourth Amendment, that is not a seizure yet. So in the case here, the guy actually throws down guns and drugs while he's running. That's going to come in under the Fourth Amendment because it was never seized. However, if the cop did seize him without some kind of evidence first, right? Drugs and guns. I think that it's a good argument of provoked flight, especially in some of your bigger cities. But in some places like Tennessee, Washington, Oregon, and New Jersey, telling somebody to come here is a seizure under state constitutional doctrines. Okay, we have State versus Roe, a case out of Ohio. And so this is kind of like their basic facts here. What happened in Roe was it was a high crime area around midnight. This guy was standing next to an idling car, which is kind of weird. It could be not suspicious, but it's a little weird. The door was open, and the guy ran immediately after the officer tried to talk to him. Is that a good unprovoked flight? Right? Yes, absolutely. We also have this case here. What happened here is a guy is sitting on some steps, okay, next to a house, right? And I got to tell you, I don't know if you guys are digging these AI animations as much as I am, but I'm telling you, it is off the. And actually, I see now that the case is actually not listed here. And Rick, do you have access? Can you email Frank and ask him? There's here. Take a picture of this, Frick, and say, take a picture of this one and tell him that the case law is missing here, and hopefully he has the original slide deck, so we can fix that, and we can put the case in here. You good? Okay, cool. Okay, so high crime area, sitting on the steps late at night. The cops got an anonymous tip of drug sales coming from the house, and when he sees the cop, he yells 6-7, like it's like code or something, to the occupants, and then starts running away. I think clearly that's a great unprovoked flight case. All right, so somebody's like, no Miranda. Look, I don't think they read him Miranda clearly. I mean, if they're not even putting the guy in handcuffs, do you think they actually read Miranda too? No, I probably not. But I do love old Danny Brown, so he gets a pass from me. But what legal issues do we have here, right? Well, based on what I taught you, um, does this a good unprovoked flight case, right? Is this a good, right? Do we have a underlying criminal activity, right? Something criminal activity in the area, right? Something that we can kind of point to. Yes. Do we have a known officer, right? Clearly, Lieutenant Brown is in a marked unit, a nice marked unit, right? A Camaro. Yes. Did he run in his runnings like screaming guilty mind? Yes, right? That is a great unprovoked flight case. Let's talk about hot pursuit. Okay. So I want you to know that the definitions I use may not be what you see in statute books or even some case law, right? So this is how I define hot pursuit. Hot pursuit is when you're chasing somebody, right? And you're like hot on their tail, right? Fresh pursuit is when you are tracking somebody down. In other words, you are hot on their trail. So hot pursuit is hot on their tail. Fresh pursuit is hot on their or fresh on their trail, right? Something, right? So, but just realize that there are, some cases that use those phrases interchangeably, but I think for the police officer, that's actually a good way of looking at it. Now, generally speaking, you may chase a fleeing suspect into their home for any felony or a misdemeanor if exigency exists. Okay. So I do want you to know that I really sincerely believe that the felony exception, is it's on borrowed time. Okay. I do not ultimately believe that based on the Supreme Court's logic in a case called Lang, which we're going to get to, I do not believe that any felony will work under the Constitution because there are many felonies that people commit that are really they're really not violent. Okay, there's no harm to anybody. I believe ultimately, right, every intrusion into the home, whether it's hot pursuit, fresh pursuit, whatever, and it's without a warrant or without consent, requires some form of exigency, not just a status offense like, oh, he committed a felony. What felony? He bounced a check at Safeway, right? And that's a felony in our state. I don't think we can necessarily run into people's homes for bounce checks, but I do believe you can run into people's homes for attempted murder, right? Okay, so one thing that we should know is where does the home begin? This is a picture of Santana's home. This is actually it's the one on the right, the kind of like the tan colored building all the way to the right. And what happened here was that I think her first name, like she went by Ma, like Ma Santana. But they saw her, she was selling drugs and she was leaning in her door frame. Okay. They said doorway in the case, but really it's door frame. And I'll explain that in a second. And she was leaning on, she was kind of like waiting for her next customer, right? The cops arrived, they got out of their car, they said, hey, you're under arrest because they already had the PC that she was selling drugs, and she ran into her home. They then pursued her into the home. Well, Santana is a hot pursuit case, and the court had to decide, hey, did that hot pursuit start in a public place? Is that door frame a public place? And public place, I should say, a place where if the police are lawfully present, they could start the hot pursuit from that point. And the answer is yes. That is where the home begins, right? Also, what you see here is you in this sidewalk, you do not see curtilage, right? So we actually have no curtilage issue either. So, but if she was inside her home, that would be a little different story, which I'm going to show you. Okay. As the court said, by retreating into a private place or house, defendant could not thwart an otherwise proper arrest that had been set in motion in a public place, the threshold of her house, right? And since there was a need for the police to act quickly to prevent the destruction of narcotics evidence, there was a true hot pursuit. And therefore, the warrantless entry by the police into the home to make the arrest was justified and so forth. And basically, they found, search instant to arrest, they found evidence in plain view. Okay. So we are good here. Okay. But you can kind of see that not only was it a legit hot pursuit, the cops were lawfully present and they could grab her from the door frame. but also there was some kind of exigency there, right? The destruction of evidence. But we also know that the entry into the home under hot pursuit is not allowed just because the person has committed a violent crime or a serious crime, I should say. Um, so what I describe here is, you know, you have an arrestable offense, right? A mandatory arrest, and the person answers their door, but they are. I hate when it does that. The whole thumbs up stuff. The hmm. Anyway, that's a FaceTime thing on my Mac. So the cop has PC to make a mandatory arrest, let's say for domestic violence, and the person answers their door. You cannot just enter the home under hot pursuit or something like that just because it's a mandatory arrest if the person's inside their home. Now, Steven says, would it be different if there was curtilage? Absolutely. Okay. What I use is the case called United States versus Smith, 2015, I believe, to illustrate that if you have PC to arrest and there's curtilage between that person and you, in Nevada, U.S. versus Smith is a case out of Nevada, but you can't just go up to that guy's curtilage and make that arrest with no other exception, because that person is almost like in their home. Okay, and you don't have, and Peyton is going to apply here. Even though you can see him, you may not be able to touch him, right? As the Supreme Court said, the Fourth Amendment prohibits the police from making a warrantless and non-consensual entry into a suspect's home in order to make a routine felony arrest. Okay. Now let's talk about Lang versus California. Here's briefly what happened. Arthur Lang is driving down the street and he's bumping his music, right? So we have a noise violation. CHP tries to pull him over, but the guy happens to be like 100 feet from his house. According to the case, Arthur, it just shows the car backed in, but AI pics are not perfect, but they are pretty good. But Arthur pulls into his driveway. I'm sorry, his garage, and he shuts the garage door on the cop, right? The cop then broke the beam, the door goes back up, and Arthur was ultimately arrested for the noise violation, but also he was intoxicated. When this went to court, the prosecution was arguing that there is a per se exception here under hot pursuit, meaning even though at the time of the entry, Arthur was not suspected of anything violent or exigency. Yes, he was drunk, but allegedly the cop did not realize that he may have been intoxicated at the time, so there was no exigency argument. But he just said, "Look, the guy's running for me. I told him to pull over with my solid forward-facing red light. Didn't pull over." And that is hot pursuit, which it certainly is under the thinking at the time, but it doesn't have any exigency, right? And so the Supreme Court said, look, just because you're running from police for a misdemeanor, right? That's why many courts still think that hot pursuit and a felony are good to go, but I would caution you on that. But the Supreme Court's like, look, what other exigency do you have, right? And there are plenty of things of exigency out there. There's protect a person from harm, prevent his escape. If you believe that by the time you come back with the warrants, the guy's going to be gone for whatever reason, you have to articulate this stuff, then that might be different. Right now, any felony, but put an asterisk on it. Imminent destruction of evidence, safety risk, something pressing, right? Something pressing here. So you gotta have something more than just the misdemeanor, hot pursuit. And let's watch this. All right. So, the first question is, legit hot pursuit. So based on what I see here, okay, just we take videos as we find them. I don't know the whole story behind everything, but based on what I see here, I see a misdemeanor, right? I see that the officer may have reasonable suspicion that the guy's engaged in criminal activity, and then him running, right? And then seeing an officer and running would be, obstructing an officer. So let's just say that the court found that this was a misdemeanor obstruction case, right? Well, that doesn't get you into homes, right? Lang says we're gonna have to have misdemeanor plus exigency. And if you see it here, that's fine. I don't quite see it here. I would not be banging on that guy's door under these facts. Now, in the old days, though, prior to Lang, that would be okay, right? That would be okay because most courts found that the running in the hot pursuit is the exigency, but the Supreme Court did not see it quite as strictly as that. And so, I think that should cops force entry? I do not think under these facts, right? I do not think under these facts we should probably back out a little bit and just rethink about how we're going to approach this. Also, there's evidence that the suspect actually fled out the back of the house. If that's true, why are we banging down anybody's door to begin with? Somebody online says, "Can unprovoked flight alone give you reasonable suspicion to go after him?" Yes, that is Illinois versus Wardlow. That is actually the point of Wardlow, is that the unprovoked flight was the reasonable suspicion. Now, you know that that alone is a reasonable suspicion is not an arrestable offense. But what happens typically, I see, is like when the cops say stop in the name of the law, the guy does not stop. The cop has a lawful right to stop them, right, under reasonable suspicion. That turns it into a misdemeanor, right, and then that becomes an arrestable offense in some places. So I'm not, not every cop does that necessarily. Just we stop them, we figure out why they're running, and then we just kind of go from there. But I want you to think about that now. Hopefully, that answers your question. So here we have a person inside their home, and they committed a protective order violation, which means that it's a shell arrest, right? Just like domestic violence in most states, you have to get arrested. The cop has no discretion, right? It's disobeying a court order. However, the guy's in his house, and it's not. He did go to the marital home, but he's not living at the marital home anymore. He's estranged from his wife, and this is not where the wife lives. So there's no exigency. Nobody's in danger, no evidence, but he opens the door, right? And the cops want to go in and arrest him, and they do so. Was that legit? And the answer was no. The way that I trained this under curtilage, right, is that, red areas you shouldn't really be unless you have some form of exigency. That door frame is, you can't go past that door frame and pull people out of their home, right? And pull people out of their home. As the court said, we have expressly refused to read Santana as allowing physical entry past Peyton's firm line without a warrant or an exigency. Santana's description of the doorway of a house as a public place, we have said, should not be misinterpreted to mean that the officers have a right to enter and arrest anyone standing in an open doorway without a warrant. I absolutely agree with this. I call this the body snatching doctrine, right? You snatch people from their home. You can't be a body snatcher unless you have some form of exigency. So remember, Santana is all about being in the door frame. Now, a lot of cops want to get cute with this, and they'll say, "Well, what if their hand is past the door frame? What if they're like holding on to their door frame, and while they're talking to you? People do that, right? No, don't play that game. I want the cops to the spirit of Santana is you're substantially in your door frame, right? Just because you have a hand on your door frame does not mean that I don't believe you're substantially complying with the case, right? So we want to get this right. Now, officers can wait for backup if they can articulate that it would not be prudent to enter a residence and once the backup arrives, So it's not like you have to charge in head first, to their home, and you can't wait for backup. That is not the law, right? The Fourth Amendment only prohibits unreasonable searches and seizures. So you are allowed to wait for the cavalry if the initial entry would have been lawful. The courts will still look at that as a continuous hot pursuit. What if you lose sight of the suspect? Look, that's not a deal killer either. There's no requirement that you have to have eyes on them every single second. People run around corners. And so what these cases come up is that the cop will lose sight of the person in an apartment complex, kind of track the person down through witnesses, maybe voices inside. They can kind of hear the guy, in the apartment, and they enter. That is also lawful if you have probable cause that they ran into a particular apartment. Obviously, get that right. Use good tactics. I'm not telling you how to, get this guy in custody, but I'm telling you, just because you lose sight of the person does not necessarily mean it's game over, okay, that they win. All right. So, fresh pursuits, right? You may enter a home after tracking down a violent fleeing suspect if you have reason to believe he's extremely dangerous, may escape or destroy evidence before you can get a warrant. Let me just get something real quick. Okay, so fresh pursuit, again, you're on the suspect's trail, right? But this, fresh pursuit is for really the most dangerous crimes, right? Um, this is not just for any felony. You have to have something very, very serious. And all right, so I want to kind of show you the search and seizure books that this is the spiral version, which is great, and this is the ones that normally our students get in our courses, right? But the point is everything I'm teaching you here, is in this book. So really, if you have not gotten this book yet, you got to check out this book. And I have a version for almost every single state. So this is the national version, and for the feds, and for but please check out the book, because it's all the stuff I'm saying to you is in the books. Thank you, Amanda. I appreciate you. Awesome. Okay. So factors, right? Here are some factors to consider when you're thinking about fresh pursuit. Number one, the gravity of the offense. Just because it's a felony does not mean we're kicking down doors. Okay. We don't kick down doors for bounce checks. Belief the suspect is armed. They don't have to have this necessarily, but usually this is a very important factor in many of these fresh pursuit cases. Clear probable cause. We don't kick people's doors down on flimsy cases. The courts really want there to be a clear probable cause. It's not necessarily required, but it's just part of good practice. The suspect may escape. Violence. How much violence was used to make the entry? In other words, the actual execution of the search or seizure is always going to be a factor in these cases, right? Did you have to, blow the door off the hinges and get the SWAT team and, using dogs and, pyrotechnics and all this kind of stuff, right? Or was it not a lot of force used and we just got the guy in custody? I'm not saying you can't do SWAT teams, right? I'm not saying you can't do that. I'm just saying these are just factors that the courts will consider when they're trying to balance out the level of intrusion and the government interest, right? Because that's really what it's all about. One of my favorite cases is the footprints in the snow case, State versus Campbell. And Rick, did we ever find? Was Frank ever able to find that citation to that case with the guy in the footsteps? Okay, okay, I might. Okay, okay, copy that. Copy that. Okay, I will. I'll figure out that case. Okay, so what happened here is after an armed robbery, the police tracked the suspects in the snow. 45 minutes later, the police saw the suspects inside a house and entered to make an arrest. Right. This is a classic fresh pursuit case. The cops were fresh on the suspects' trail. Right. The suspects were dangerous. The cops were on their trail. Classic. Right. Classic case. Here is a very sad case, People versus Gilbert, an older case from 1965, but nonetheless, what happened here is a cop got killed during a bank robbery. So a bank robbery killed a police officer. The police tracked the suspect to his apartment within 2 hours and arrested him. Is this a good fresh pursuit case, right? And the answer is yes, right? The answer is yes. That guy is a danger, right? And it's a current danger. He just killed a cop. He's armed. He's in. You're just giving him time to, create an ambush for you to fortify his position. And that's what these fresh pursuits case are all about: is to get this violent person in custody as soon as possible.
Yo, is that cool? Him too. Put it out. Get it out. Oh! What? Okay. Okay. Money in the bag. I touch it open. I touch it open.
Faster. More. Under.
What? Where?
Under the thing. Under.
Where? Here?
All the money. Get a card in this one.
Where? The Newport? Okay.
Yeah.
And then there's Cody, who no mask. He took his mask off, no gloves, leaves his wallet behind. He looks like an idiot. And that's why all we got to be is just a little smarter than the criminals, and we do a good job, right? So the point is that is a good fresh pursuit case, right? What if a witness gave you a license plate and the car was in the driveway and the house lights were on, like let's say 40 minutes later? Is there do you think the courts will back your play here that they would allow you to enter that home to take that guy those two into custody? My answer is yes. I think this is a good fresh pursuit case. Armed robbery is definitely an extremely violent crime. These guys are dangerous people. They're armed. I'm not saying you would do it. A lot of agencies are not going to just kick down doors and go taking people. They're gonna do a surround and call out, and they'll like to say smoke them out for the next few hours if we need to. But they're not going to put their officers on the line just like that, brazen like that. They'll just smoke them out. That's fine. Okay, that's repeated. All right, let's watch this. One of my favorite. This is another great video. I call this video the Snow Whisperer. All right, I gotta tell you, I told you the Snow Whisperer. I mean, that guy, he knows his tracks. I don't know what he did before, before becoming a police officer, but it might involve hunting or something like that. But the cop did a very, very good job. Look, it wasn't, fresh pursuit, quite frankly, is usually an issue when you're entering the suspect's own home, right? Here, you're not even entering his house. He doesn't live there. So it's not really, you don't need fresh pursuit to save the day because he has no reasonable expectation of privacy in where he's at. However, cops would still call this a fresh pursuit case because it looks like a fresh pursuit case and so forth, even though legally he can't complain about why you're there. So whether it's no exigency or exigency, either way, the cops are lawfully present as to him, if that makes sense. Okay. I want to talk about protective sweeps. That's something that obviously comes up a lot during these cases. There are 3 types of protective sweeps that you may conduct during an in-home arrest. And actually, I'm looking for that case, by the way. I don't know if I found the exact case. I don't have time to read it, but I'm going to send it to Rick because I can't. It's on my computer. I'm going to send it to Rick on my laptop, and then he's going to send it. He'll put it in the Zoom chat because these are not connected. Okay. Thanks, Rick. That's a good case. I think that's a good case either way to answer your question about, hey, a person yelling something and then running. So hopefully whoever is looking for that case name, that'll at least get you the doctrine that I was talking about. So what I teach here at Blue to Gold is that you have areas under the immediate control. That is kind of an automatic, comes with the arrest type of deal, right? You may search areas under the suspect's immediate control. Is it at the time of the arrest or at the time of the search? That's a debate. Usually, to say the least, at the time of the search, those things that he may be able to grab and so forth. You can look for weapons, evidence, means of escape. You can also search adjacent areas. So this is the scenario. The guy runs into his house, right? That's when it's going to be an issue. He runs into his house, and he runs into his bedroom and hides under his bed. And then you find him under his bed. You then look in his closet and you find a sawed-off shotgun in plain view, right? That's coming in. That closet or bathroom is adjacent to the area of the arrest, right? So you can look for people in people-sized places. Now, you're not looking for means of escape and you're not looking for evidence. You're looking for people in people-sized places. That's why you're concerned, because he can't reach it, but you don't want his Confederates, right, i.e. his associates, to jump out, of another room or something like that and attack you. And then finally, throughout the home, right? Throughout the home requires some level of articulation. You may search for people in other areas, like beyond the arrest area, right? Beyond the adjacent areas, but you are going to have a reason to believe that there's somebody that could be a danger there, right? A lot of cars in the driveway, gang house, the 2 people committed the armed robbery, but only he's present, right? Where is his Confederate? Where is his partner in crime? Can he sweep for weapons too? Generally speaking, no. No, you're searching for people in people-sized places. But I will tell you, there is some case law that says that if you have a reason to believe that they can grab a weapon, right? That somebody can go grab a weapon, then you may be able to seize the weapon because you're trying to prevent them from becoming armed and dangerous. Let's look at this. All right, so let's just presume that's his residence, right? You know, it's not clear. It could be a flop house where it's not his residence, but let's presume, for argument's sake, that is his residence, that is his domicile. Look, I don't, legit hot pursuit. Sure, they have an arrest warrant, right? But what about this? You know, what protects the sweeps, right? Things that are in his immediate control, fine. Adjacent areas, when they're in there, can they look into that closet area? You know, and and sweep it. Sure, it's adjacent to the arrest. Absolutely, they get it automatically. That's fine. But throughout the home, right? In the reentry, right? I'm with Tyler on this one. That I do not see the authority to re-enter that home. I think they're doing what's called a show and tell, and that is not permissible under the Fourth Amendment. That is, if that is this person's domicile, you cannot just do show and tell because you know, I mean, let's be honest. Some cops have been inside homes where the people imbibe methamphetamine, and there are certain toys strewn about, and they bring in their detectives to do show and tell, and it's not really to go get a warrant. It's not really. It's more just to be. They want to laugh, and that's that's unlawful, right? The courts are not going to be very happy that cops would be doing show and tells on those type of situations, right? So it does happen. I've heard of this happening. I've seen it happen, but it shouldn't happen, right? The reentry here was probably unlawful. Okay, Plainview seizures before we call it a day. So, and do some trivia, and we're gonna do a search and seizure show with my friend Chris McFarland. Plainview is nothing more than you are lawfully present and you don't manipulate anything, right? That's what Plainview. Plainview is nothing more than right to be, right to see. If you want to seize something, if you want to put your hands on it, then you have to have lawful access, right? Lawful access. That means that you don't have to make another intrusion to grab it, right? To seize it. And the best case for this is Lewis versus State. What happened here is that cops thought that Lewis was involved in drug trafficking, possession, trafficking. He was seen stuffing drugs. I'm sorry, he was seen stuffing something in his stairs when the cops pull up to his house. Lewis came out to the curb. He was detained. The backup officer then went to Lewis's neighbor's house, and he can see the drugs inside the stairs. The cops then went over to Lewis's stairs and grabbed the drugs they just saw in plain view. And I got to tell you, out of Chris, out of 100 cops that we train on this case, how many would have done the exact same thing before we trained them? How many, McFarland, out of 100? And so here, the cop is calling it plain view. It's plain view. You can see it, but you just can't touch it, right? I would say probably 60 to 70 of them would probably do the exact same thing, right? But they misunderstand the plain view doctrine. As the court held, it is true that not only must the officer be lawfully located in a place from which the object can be plainly seen, but he or she must also have a lawful right of access to the object itself. Police officers are prohibited from entering a person's home or its curtilage. Don't underestimate the power of curtilage without a warrant, absent consent, or a showing of exigent circumstances. This is true even when the items of contraband are visible within the officer's plain view. And I got to tell you, when I read this quote, it reminded me of one of the most, I don't know, one of the funniest quotes I've ever heard from a judge. And it was from 1975, but this is what the judge said. First of all, it involves a word called burlesque. A burlesque house is a strip club, and I'm raised in Las Vegas, Nevada, which is the mecca of strip clubs. It's like our national pastime, I guess, here. So seeing something in open view does not, of course, dispose of the problem of crossing constitutionally protected thresholds. Those who thoughtlessly overapply the plain view doctrine to every situation have not yet learned the simple lesson. long since mastered by old hands at their burlesque houses. You can't touch everything you can see. So in the back to the Lewis case, what would have saved it? What would have saved it is having some level of agency, some kids playing around the stairs, a girlfriend that's going to go grab the drugs in the meantime, something, right? Somebody, a friend near the drugs, some kind of like, hey, I can't wait to go get a warrant because I'm going to lose my evidence, something like that. But since the cops did not have any agency in that case, evidence was suppressed. Guys, real quick, did you find this information useful? We've been here really going out for an hour. I want to do some, give us some love, hopefully. Also, if you guys like what we're doing here, but please, we have our whole staff on here. We have Rick and Teresa and Chris McFarland and Breland, right? Who, if you guys want to host us, you want to bring, our legal instructors, we got, proactive patrol, we got undercover operations, we have narcotics investigations, we have search warrant report writing, we have interview and interrogation law. Dude, Blue to Gold is your source. And I'm not trying to be like a commercial here, but I give you guys a lot of love. I would appreciate it if you guys want to bring out one of our instructors, reach out to us. Email, all you got to do is email. Oh, Mike is here, of course. Mike Arena is here too. Email training@bluetogold.com and say, hey, I'm interested in some training. We'll figure out what kind of training you're interested in. We'll get you with the right people. Yep, all the people. One day we should really actually have like a webinar with all our staff, saying hello. I think that'd be kind of cool because so many people follow us and they this is not a one-man show here. Not even close. Not even close. All right. So give me a quick review. This is my Rick. Isn't this like my ice? What was it? Zoolander. My Zoolander pose, right? All right. So for those who are watching on demand, I'm going to shut off the recording now. And I really appreciate you guys. Thank you so much for being here. And I'm going to return in a few minutes with a Search and Seizure show, but I'll make a brand new recording for that. If you want to watch our Search and Seizure show where I answer questions live on Zoom, or I should say, it's gonna be on YouTube. Just go to YouTube and watch it there on the YouTube channel. All right. All right. Thank you guys for watching and share this video with your friends. You can download it. You can sell it for $1 million if you can make it, whatever you want. Just, I hope you guys got something out of it.